Hey, everybody. Welcome. We are going to wait for a few minutes to get everybody logged in. We do not have the Q&A turned on tonight. We're just going to give you a quick update of the vote and what we're working on, and there'll be more to come. So give us a few minutes to get started. Evening, everyone. We're going to get started here in just a few minutes. Once I see the dial-in slow down a little bit. We do not have the Q&A on tonight. We're going to probably not go more than 20 to 30 minutes. We're going to give you an update on the vote, what that means, talk about what we've been working on this week, and then the timeline for what's coming. So give us just a few more minutes and we'll get started. If you're looking at this main slide, you will see that the Omni Solutions phone number and email address is there. If you are wondering how your vote was recorded with Omni, you can reach out to them via email or phone and ask. So that's up there for you. Hey, Deb, I think we should go ahead and get started. It's kind of flattened out a little bit. Hi, everybody. John Humphrey and Doug Kennedy here with Richard Pachovsky, Jim Stang, and Deb Grassgreen. Really appreciate you all joining us tonight. I know there's been lots of news and lots of press. And before we get started, I just wanted to thank everybody for voting. Regardless of whether you voted to support or reject the plan, we just really believe it's very important for you guys all to express your voice on this matter. We're going to talk about what it all means in a little bit. My standard disclaimer that we're not here to give you legal advice. We're here to just educate you about the process, where we are in the case, what comes next, and things that you might not otherwise know if you haven't been immersed in bankruptcy for the last several years. So with that, I will turn it over to my co-chairman, Doug Kennedy, to say a few things and get us kicked off. Doug?
Thanks. Excuse me. Thanks, John. Good evening, everybody. I'm going to keep it very, very brief. Like John, I just want to thank everyone who voted, whether you agreed with the TCC's viewpoint and voted to reject this plan, or you voted to accept it. We respect and recognize and want to thank everyone who took the time to vote. John and I are survivors. The other 7 members of the TCC are survivors, and we know how important it is to feel like you have input and some degree of control over this whole situation. I also want to mention that we've received a lot of emails, had a lot of contacts from people that are really saying, what now, what now, what now? Like, how soon is this going to be over? And, trust us, the TCC has lived this for the last 2 years, practically on a daily basis. We've been in mediation all this week and are continue to be. So we understand those feelings, but at the same time, bankruptcy has got its own sort of flow. And we're just want you guys to know that we are working and fighting so hard. We said that's what we were going to do. We wanted to see this plan rejected and get back to the table. And that's happened immediately. And we are fighting our asses off for everybody. And the only last thing I want to say is, it's a tough time of the year. It's the winter. We've got Omicron now. We've got this bankruptcy hanging out there. It's tough sometimes to keep your head up. I just want to remind everybody, we do have some mental health resources on the TCC website So please refer to those if you feel like you need any help to get through this. We're going to continue to have these town hall meetings, and please check the website to keep you as informed as we can. So just want to let you know that we are fighting hard for you now. So everybody hang in there. Thanks, John.
Thanks, Doug. So, we've been saying all along that there's a few things we really care about in this process. We care about the youth protection. We care about the way the trust is governed. We care about the dollars that the local councils putting in their fair share. There's also a legal issue that I'm going to let Rich talk about later on. But what we told you all along is if this was not a slam dunk in the favor of the plan and the Boy Scouts, that we would be back to the negotiating table and that we would come back with a voice and we would have an audience. And I think that's exactly what happened. We didn't even get the final count of the vote until Tuesday, I believe, and we were back in mediation on Monday. So I think every moment except some time on Wednesday, there have been mediation meetings. All of those issues are on the table, and can't really divulge whether we're making progress or not making progress, but we are certainly being listened to. And we think we have the pathway to get this plan improved for all survivors. So with that, people get hung up on the vote. It was 73% in support and 27% to reject. If you back out the quick pay claims, it's 70-30 right down the line. And everybody's been so fixated on the vote, us included, right? But it's only one stepping stone to how the judge views this case. And so I thought I'd let Jim Stang give us sort of an overview of what the voting means and kind of what is it in context around, just one of many things. So Jim, maybe you could speak for a few minutes.
Sure.
On that, and then I'll have Rich talk about some of the issues that we're facing.
Okay. So the Bankruptcy Code has a section, for those of you that got your bankruptcy codes for Christmas, it's section 1129, and it sets forth section 1, 2, 3, 4 of the things the court has to determine in order to confirm, which is our word for approve, a reorganization plan. There are more than a dozen things the court has to find. Some of them are factual. Rich will talk about that a little bit. And some of them are purely legal. Can the plan do X, Y, and Z? And Rich will talk about that. One of the factors, it is a factor that the court looks at, is the vote. And that's the vote that John referenced. 73-27, kind of with all claims in our class, which are the abuse survivor claims. And if you netted out the people who took the expedited payment, 70-30. But there's been a lot of press over the last few days about whether the plan hit 75%. And remember, these percentages are always of the people voting. It is not 75% of the 82,000 plus claims. So where does the 75% come from? Is there a 75% requirement? And the answer is no. But people talk about it all the time. So where does it come from? One of the things this reorganization plan does is it extends treatment of the claims that you all have or may have against the local councils and the chartered organizations. And Rich is going to talk more about that. Not a single local council has filed bankruptcy, and nearly none of the chartered organizations have filed bankruptcy. There are a few that are in bankruptcy, but it's not, it's literally a handful. And if the Boy Scouts had filed the plan that dealt only with the claims against the Boy Scouts and not the claims against the local councils and not the claims against the chartered organizations, the Boy Scouts in a case like this needed 66% of the people voting to vote yes. The formula is a little more complicated in a regular commercial case, but because practically no one has a dollar amount that has been put into a judgment on their claim, in this case, it's 66%. But the Boy Scouts didn't file a plan that just dealt with the claims against the Boy Scouts of America. They dealt with a plan, they filed a plan that dealt with other entities, the councils and the charters. So if this company were an asbestos company, there is a specific bankruptcy code section which says, if you want to get a plan approved for an asbestos company, 75% of the people affected by the asbestos have to vote yes. I can, again, open your bankruptcy code, turn to section 524G, it's in there. Now, let's try to find what the voting margin is when a non-asbestos company is trying to confirm a plan that gives relief to charters and locals who are entities that have not filed bankruptcy, non-asbestos. There is no bankruptcy code section with that number. But lawyers are asked all the time by their clients, what do I need to get this plan approved? And so when you're dealing in a case like this, which is not an asbestos case, lawyers look to the asbestos statute for guidance. Congress said, in an asbestos case, you need 75%. And I don't think there was anything magic about it being an asbestos case. They wanted to deal with the asbestos problem, and some congressmen and senators thought 75% sounds like a good number. So when a lawyer is asked in a non-asbestos case, how many votes do I need to get this thing over the top? The answer that I give is not less than 75%. And then the client, of course, says, so I only need 75%, right? And the answer is no. You can't have less than guidance. My sense, my professional judgment, you really can't demonstrate to the court that you've got this overwhelming creditor support if you come in at under 75%. But there are courts, and these are in the books, in our library, which say, some judges will say you need 90%. Some judges might say 85. It's not a hard and fast rule in a non-asbestos context if you're looking for a specific number. So that's where the 75% comes from. People use it because there's nothing else to look to in our bankruptcy code that will give us guidance. But please remember, it is not, if they had 75.2%, some people might still argue that's not enough. It is a guide and only that. So, as I said, there are more than a dozen things the court has to determine as part of confirming or approving a reorganization plan. And I'm going to ask Rich to focus on the two that we think are the most important for you to understand coming out of tonight's meeting.
Thank you so much, Jim. And again, this is really complicated for those of us who do this every day. And so we're going to try to put this in perspective as to what in some respects, and Jim did, what the vote means. And even if you get past the vote, what else has to occur for a Boy Scout plan to be confirmed so it goes effective one day. I think it was critical, just so people know it, that the no vote came in, causing the yes vote to be under 75%. Jim said it's a minimum. That's what many of us who do this every day think. And getting below it, what it really did in this case is it allowed us to effectively get back to the mediation table. And as John said, we got back Monday, and we're working as hard as possible because the goal is to come up with something that is higher compensation, that is fair on youth protection, and that has an independent trust governance. We've made that very, very clear, and that's what we're fighting for. But the other thing that we're really fighting for is really a fourth aspect, which is to make the plan actually confirmable. We can get all three of those things, but if we don't comply with the law, then it doesn't get confirmed. Now, just as Jim said, there are over a dozen requirements. And there are some, if some of you end up following the confirmation hearing, which starts on February 22nd, that's when it's set. And there are a number of depositions that are going to take place before then. And there is the final voting report, because all the votes are being audited, so it's fair, on January 17th. So hopefully we will have a final count, which I suspect, based on history, will be effectively what is out there right now, which is basically 73 to 27. But by it being under 75%, we think it helps us get to a fair resolution with all the parties. No guarantee, but if you don't get above that number, there's really, it's highly unlikely, if not impossible, that you can confirm a plan. But just because you get over it, even if we had gotten to 90%, even if that would have happened in 90% acceptances, it doesn't mean the plan is confirmed. Why is that? Because here are some of the tests that have to be met. A plan has to be feasible, means that if it's supposed to be a reorganization, that it's not likely to be followed by a liquidation. Well, I won't get into that in detail, but that's usually an economic analysis as to the company. The other one that is important is best interest of creditors, which is important for the survivors in particular, because the debtor has to prove that the company is effectively, or the Boy Scouts are effectively, paying the various creditors and the survivors at least as much as they would get if the Boy Scouts were liquidated. That's one of the things we believe that is not being complied with, independent of the vote. The vote could be 100%, it wouldn't matter. The Boy Scouts have to prove that. The Boy Scouts also have to prove that the releases that are being granted are fair and are legal. Now, Jim, when we discussed it today, and we've spent a huge amount of time on this release issue, is releases under the plan are being granted to, among others, the local councils and the charter organizations. Organizations that are basically just trying to follow the coattails of the Boy Scouts, which went and filed Chapter 11. And the charter organizations who did not file Chapter 11, who are clearly liable for so much of the abuse, are getting a pass just because the Boy Scouts filed. The courts don't allow that in most cases, and it's fairly complicated analysis. But even if the vote had come in positive, the court would not only have to find that the vote was sufficient, but that the releases were legal. And we do not believe that under the law in the Third Circuit, which is where Delaware is, where the case is pending, that the releases would be legal. Now, some of you may have read in the paper about Purdue and the issue of releases in that case, and this is different than Purdue in many respects, and that's in a different circuit, that's in the second. But the issue of the releases is probably the most significant, or at least one of the two most significant issues I've seen in my 42 years of practice. And it's an issue Congress is looking at, it's an issue the courts are looking at, and it will be a major issue that this judge will be looking at. And so our goal through a mediation process is not just to get higher compensation, which is critical, and not just to get an independent trust, which is critical, and not just to get youth protection, which is absolutely critical, but to get a plan that's actually confirmable, because we can get all three of those things and it's not confirmable. And that is what we're going to work to do. And whether it's 24/7, as far as I'm concerned, it's what the TCC is doing, and it's what our team is doing, and what the other teams that are working with us. And so
the good news is, Rich, hold on just a second. But the good news is that there are ways to accomplish all four of those things. So, and that is what we're working on.
Yes, correct. We believe there's a pathway. John is 100% correct. There's a pathway. We have discussed it internally how to do it. We're going to work with all the parties to try to get there. There's no guarantee, but I think everybody is going to, I hope, going to act in good faith to get there, so that we don't go down a path that at the end of the day, the court says, I'm not going to confirm the plan, even though it may have given us everything we wanted. We don't want to end up in that position where millions and millions of dollars are spent and wasted.
Yep. Thanks, Rich. Jim, did you
Thank you.
have a follow on that?
Just two things. Seems like a couple of meetings ago, I and Rich and maybe John Lucas said to all of you, if the vote comes in short, which it has, we're going to be back at the negotiating table. And John talked about this. And there were people who said, that's not what's going to happen. Everyone's going to go into their respective corners. I always use the analogy, it's like dropping mercury on the floor. Everyone's going to scatter, and we will never be able to put this together. Well, folks, Monday morning, Rich and I and Deb and John and Doug, we were all back at the table. And we all knew that was going to happen, because that's how life works, right? You know, and it's really important stuff. You always come back and you talk about it again. So, yeah, that turned out to be right. Now, God willing, we'll get you a settlement that we can make a recommendation on. Rich said something about liquidation, and I didn't want people to come away with the impression that the committee is advocating for the liquidation of the Boy Scouts. What Rich was talking about, and he was clear, but I just, sometimes try to anticipate how people can be misunderstood. There was a floor of how much this plan of reorganization has to generate for creditors. And that floor, that measure, is what would creditors get if the Boy Scouts were put through a liquidation proceeding. We want that and more. We are entitled to that and more. And so please do not come away tonight with the impression that the TCC is calling for the liquidation of the Boy Scouts. The Boy Scouts and the insurers and whoever else is trying to get this deal done need to pay more than what you'd get if the Boy Scouts went through a liquidation. That's our measure. That's our floor. It is not our objective to liquidate the Boy Scouts. So, John, I just wanted to add that.
Yeah, I appreciate that, Jim. And what you guys have taught me over the last couple of years is that a nonprofit in the United States cannot be forced into liquidation. They can only choose to go there. So, our tone has been conciliatory tonight. You've heard the harsh tones before. You've seen the videos where Doug and I dug in on this, and we are not gloating in the way the vote came out. We are excited that, I've witnessed the mediation this week, and I can tell you that we're really being listened to, and that people are having really substantive and deep conversations to get around some of these really complex issues. And so I think we're making progress, but time will tell, and there's no guarantees of anything. But we just wanted to come on and spend about 30 minutes, give you an update, tell you what was to come. The final vote audit is finished on the 17th of January. There are tens of depositions, I think almost 50 that are going on that are supposed to be done before the end of January on both sides. So that's just going to be a massive amount of work. There's a status conference with the judge where all the attorneys get together with the judge on Monday, kind of like so she can see where are we. And then, as Rich said, February 22nd is the beginning of the confirmation hearing. So a lot of ground to cover. Doug, any last thoughts before we sort of wrap things up?
Yeah, it's probably just worth reminding everybody that we'll post the date and time of our next meeting, but that's probably going to be subject to change to whether or not there's any developments. So the best we can do really is just ask you to continue to check the TCCBSA.com website on a regular basis. And as soon as we know that there's going to be a meeting, we'll put up a new notice and try and give you as much time as possible.
Yep. And as we end, we've got the TCCBSA.com that Doug just talked about, TCC questions at pszjlaw.com. If you have questions, you can submit them. We are addressing and answering all those that come in. And then if you want to know how your vote got recorded, you can either call Omni and give them your claim number, or send them an email at BSA ballots at Omni agent, no E in that agnt.com. So with that, thank you so much for voting. Thanks for joining us tonight. Keep your fingers crossed. We think we can make some real progress with the other side. So hopefully we'll have something to report. Have a great evening, everybody. Good night.
Good night, folks.
All right, everyone.